Hello everybody, welcome for this match of the 8th final of the Hague Inter-University Law Debate Tournament organized by the Corax Foundation together with my colleagues Miss Urbanova and Miss Varley today. So today we have two teams out of the 16 teams who qualified for the 8th final, one in Brazil, which is Dommelder Law School, and one in the Netherlands, which is Tilburg University. So both teams received 10 days ago a topic to prepare for this debate, and before we move to, of course, the topic of the match and the match itself, let's start with just an introduction between the teams. So maybe we can start with Mr. Zhang. Could you introduce yourself?
Yes, thank you very much. I'm Andy Zhang. I'm currently studying global law at Tilburg University, currently a first-year student, and I'm very delighted to be here.
Thank you very much. Mr. Fabricio Lafuente Peña.
Hello, greetings to all. Good evening to my fellow colleagues in Europe. My name is Fabricio, and I am currently a fourth-year student in law representing the THIULDT team.
Thank you very much. Mr. Radmer Khosrow-Kavar.
Hi, I'm Radmer. I'm a first-year global law student at Tilburg University, and I'm honored to be here.
Thank you very much. Miss Laura Grip-Rosas.
Hi, my name is Laura. I'm in the third year of law at THIULDT University, and it's a pleasure to be here with you today.
Thank you very much. And Mr. Fransawi.
Hi everyone, my name is Fransawi. I'm also a first-year global law student at Tilburg University, and I'm excited for the debate.
Thank you. And Mr. Lucas Tabañas Murta de Sousa.
Greetings to all my colleagues around the world. I'm very happy to be debating today, and I hope for a successful debate for all. Thank you.
Thank you very much. Maybe as well as a coach, I could start with Dr. Bastianetto.
Thank you very much, Professor. I'm sorry for not having my camera on, but it's a pleasure to watch this debate and to take part in the 80s of the Hague debate. Thank you very much, and good luck to all.
Thank you. Mr. Telemans.
Hello everyone, I'm also a student at Global Law. I'm here in Tilburg University, and I'm joining here as coach and hope to enjoy this debate.
Thank you very much. So I think today Miss Urbanova will take care of the timing, yes?
Yes, I'll be doing the notifications, so when you have 30 seconds left from your speaking time, you will see me show up the first notification, which is a yellow note, 30 seconds remaining, and when your time is up, you'll see a second notification, a red one. You can still finish your sentence, of course, but afterwards we will ask you not to speak anymore, and this can also be penalized by the judges in the grading form.
Thank you. And Miss Varley will be hosting the match, right?
Yes, that's right.
Yes, so hosting the match after, of course, the allocation of the positions. So I will share my screen. So so first, the topic you got. So the topic you got 10 days ago was, it is a violation of human rights when lockdown is applied indiscriminately in a region affected by a public health crisis. So this is the topic you received. You had to prepare both sides, and in favor and against. And now I will share my screen, so everybody will be able to see the allocation of position live. So, up. So in a few seconds you should see. So you should see that there are two positions for each team to be in favor or to be against. So now I will simply click and we'll know which position okay. So against is Tilburg University on this motion. So it means in favor is Dommelder Law School. So it means as well that Dommelder will start the debate with the opening statement after the 5 minutes of preparation. So just to clarify, Dommelder Law School will defend the position that it is a violation of human rights when lockdown is applied indiscriminately in a region affected by a public health crisis. and on the other side, Tilburg University will defend that it is not a violation of human rights when a lockdown is applied indiscriminately in a region affected by a public health crisis. So now my colleague will share a screen for the 5 minutes, so you can review your notes and argumentation. You can close your camera and audio, and in 5 minutes we'll start with Dom Elder with the opening statements of 4 minutes.
Well, the time is up. We can start. We can proceed with the opening statements. So, first of all, I would like to give the floor to the Domhelder Law School, and you have 4 minutes for your opening statements. Do you hear me?
Sorry, can you please repeat? I couldn't hear you.
Oh, sorry. I think I had an issue with my microphone. So we can start with the opening statements. Firstly, I would like to give the floor to the Domhelder Law School. You have 4 minutes.
Thank you. First of all, am I audible and visible to everyone?
Yes.
Okay.
Yes.
Implementation of isolation, quarantine, refusal of entry and exit of persons from national territory, and generalized businesses shutdowns are policies included in the wide term lockdown, one of the most extreme and severe sanitary measures that consist in suppressing individual and collective rights, such as the rights of freedom to movement, freedom of association, freedom of assembly, residence, expression, and so on. Honorable judges, counterparts from Tilburg University, my name is Fabrício Lafuente, and today, along with my fellow colleagues Laura Rosas and Lucas Cabanes, we defend the thesis that even though the international law prescribes extraordinary possibilities for derogating those human rights mentioned, the indiscriminate application of the lockdown violates human rights considered in the righteous perspective of indivisibility, interdependence, and interrelation. Our thesis stresses 3 main points: the need for states to comply with procedural and material requirements when derogating the exercise of human rights, the discretion of that the international law gives to each country to apply those measures, always with a different approach between those who are healthy and those who are ill, and lastly, the positive obligation in Article 43 of the International Health Regulations for states to apply less intrusive measures in the juridical realm of the peoples. It is clear that the indiscriminate application of the lockdown must be comprehended as contrary with the evident dispositions from conventions for limiting or ultimately derogating the exercise of human rights, which must be protected against the acts of states, the main human rights violators. In accordance with the Inter-American Court of Human Rights in its Declaration 120, any strategy to contain the spread of a disease must be temporary, proportional, and based on scientific evidence. The International Covenant on Civil and Political Rights in its Article 9, the American Convention on Human Rights in its Article 30, and the Banjul Charter in its Article 6 all require that states parties enact formal legislations when restricting the exercise of human rights, always basing on the necessity of such policies. Furthermore, the states must be transparent with its population through the notification of derogation and the legislative due process for the lawmaking decision in these extremely difficult times. In parallel, the International Health Regulations, the most important health convention related to this topic, is very clear when differentiating the concept of quarantine as distinguishing those who are ill from those who are healthy. In addition, the positive obligation for states to safeguard their population implies a different approach between those who are tourists and nationals, residents, and refugees in their territory, imposing the prohibition of entry in all points of access to the country's territory, as well as travel bans to foreigners that can have their entry postponed. Lastly, the same health regulation provides that states shall apply less rigorous measures when those are equally capable of achieving the sanitary goals to protect collective health. This duty is under the reserved domain of states and must involve a thorough impact analysis on job loss, housing security, mental distress, poverty levels, and financial hardships. Again, those analyses must be carried out with a careful distinction between all of these variants in the population of a country, and not indiscriminately, entailing differentiated possibilities and approaches which shall enable the most adequate protection for the most vulnerable populations in all aspects of their lives. Thank you.
Thank you. Now, I would like to give the floor to the Tilburg University. You have 4 minutes to deliver your opening statement, taking the position.
Yeah, am I visible and audible for everyone?
Yes.
Okay. In the words of Gordon B. Hinckley, you will come to know that what appears today to be a sacrifice will prove instead to be the greatest investment that you will ever make. Ladies and gentlemen, Today we are here to present our strong opposition to the debate statement which reads, "It is a violation of human rights when lockdown is applied indiscriminately in a region affected by a public health crisis." It is our firm belief that lockdowns in protection of public health do not threaten human rights, but instead strengthen and protect human rights in our modern societies. Today we will present our concerns about the debate statement from two main axes. Firstly, from a legal perspective, and secondly, from a more societal and pragmatic one. In our international legal framework today, the right to freedom of movement is protected by a variety of treaties and declarations which we consider to form our customary international law. And today we expect the proposition to argue that the freedom of movement is an inviolable right. However, we must remind you today that, like most rights, the freedom of movement is not absolute in its character. In fact, this is reinforced by a plethora of international legal treaties. For example, Article 12 of the International Covenant on Civil and Political Rights, a legally binding document, proclaims the right to freedom of movement and also states, "The above-mentioned rights shall not be subject to any restrictions except those which are provided by law and are necessary to protect, among other things, public health." This notion is further reinforced by other core legal documents such as Article 2 of Protocol 4 of the European Convention on Human Rights, Article 12 of the African Charter on Human and People's Rights, among others. Additionally, the International Covenant on Economic, Social, and Cultural Rights first established in its Article 12 the right of everyone to the enjoyment of the highest attainable standards of physical and mental health. And it stipulates that state parties must ensure the full realization of this right to health by taking steps such as, and I quote, "the prevention, treatment, and control of epidemic, endemic, occupational, and other diseases." The right to health has been reaffirmed in the aforementioned International Covenant on Civil Political Rights, the Universal Declaration of Human Rights, and other key international legal documents. Having established that lockdowns are necessary to protect the fundamental right to health of peoples, we will now move to a more pragmatic approach. Today, we argue that lockdowns do in fact protect public health. In essence, lockdowns work. We urge you to look at some of the the countries that have imposed the strictest COVID lockdowns and measures. China, for example, until a recent outbreak, had only recorded approximately 84,000 cases for almost 2 years of a pandemic which devastated the globe. Keeping in mind we're speaking about the most populous country on earth here. Even today, China has only recorded 5,191 COVID deaths. The United Arab Emirates, which imposed stringent COVID lockdowns early on, has only recorded 2,300 COVID deaths. Singapore has only recorded 1,352 COVID deaths. New Zealand, which gained international notoriety for its extremely strict lockdowns, has only recorded 826 COVID deaths, a surprising number for a country of 5 million people. There's a multitude of infinite examples we can refer to today to show the effectiveness of reducing COVID cases and deaths through lockdowns, which we view as clear evidence of lockdowns protecting public health and, by extension, the fundamental human right to health. Today, my colleagues will expand on the aforementioned safeguarding of the right to health and the provisions in international law which ensure the legality of such actions. Also diving into national administrative laws which would allow such measures. It is for all of these reasons that we come before you today in firm opposition to the debate statement. Thank you.
Thank you. So now I give the floor to Domhilda Law School. You have 2 minutes for your first rebuttal.
First of all, am I visible and audible?
Yes.
Your Excellencies, it is obvious that the limitation and derogation of rights is possible, but our thesis consists in the indiscriminate approach. And we are not opposed to the appliance of a lockdown when it's necessary, but some considerations must be made. The application of any emergency measure that may endanger the compliance with human rights must be closely regarded. That's why there are requirements before states to hold back fundamental rights such as necessity, proportionality, and legality. In this sense, when imposing such restrictions, states shall immediately inform the international community through the intermediary of the Secretary General of the United Nations by the provisions derogated and the reasons why it was enacted. Moreover, the juridical concept of equity entails for a fair treatment for people who are historically uneven, including those who are more vulnerable during health crises, such as the ones living under the poverty line. Data from the United Nations proves that during the pandemic, the absolute number of people living in extreme poverty rose for the first time since 1997. We shall highlight that the most economically affected states are the ones from the underdeveloped parts of the world. Thus, states, when applying measures to contain the spread of the virus, must take into account the social and economic conditions of its population in order to mitigate its impacts in a transparent and distinctive manner in accordance with Article 43 of the International Health Regulation. Thank you.
Thank you. Now it's the turn of Tilburg University, so I give you the floor for 2 minutes.
Thank you very much. First and foremost, am I clearly audible and visible?
Yes.
Thank you very much. So the opposition wants to react to the opening statement made by my distinguished colleague on the other side. They have mentioned certain problems with regards to the debating statement with regards to legality, the international legal framework, and the intrusivity. However, we are of the opinion that such indiscriminate lockdown is in accordance with international law, as for instance seen in Article 12 of the International Covenant on Economic, Social, and Cultural Rights, which obligates states to ensure that there is a medical system and a mental health care system in place in the event of an event to ensure that people have access to healthcare, even in the case of an epidemic or endemic virus or situation. And with regards to the intrusivity of such measure, we are of the opinion that such intrusivity is proportionate and balanced, as it is important to realize why a particular nation, not one nation, but we can see this around the world, imposes such lockdown. We do not see that the nations do this because they arbitrarily try to take over control of society, they want to ruin their economy for arbitrary reasons. No, we see that it's actually necessary. We see that within nations, which were reluctant to announce an indiscriminate lockdown, that we see that their entire healthcare system almost collapsed. We can see this, for instance, in Italy at the start of lockdown, where there was a reluctance to do whatever, like, was it proportionate to impose an indiscriminate lockdown. And we see that people eventually did not have access to that healthcare that was actually obligated by states to do so under international law. We see that this has become a threat to the public and physical health of people, but also the mental health of people, as the public healthcare system was not able to provide for mental health assistance, which was very damaging the people that were struggling with mental health. For instance, seen in the rise of mental problems, of anxiety, of depression. So therefore, based on these assessments, the opposition is of the opinion that such lockdown is in accordance with international law and is intrusive enough.
Thank you. Sorry, your time is up. Thank you. So now we can proceed with the second round of rebuttals. I would like to give the floor to Domhelder Law School. You have 2 minutes.
So what my counterparts did not understand is that arbitrary measures have nothing to do with indiscriminate measures. Discriminate treatment is proven by the Family Reunification Directive from the European Union, which was applied during the pandemic to prevent disproportionate attack on families. Moreover, the paradigmatic case of Pablo Vilches and others versus Chile, judged by the Inter-American Court of Human Rights, in which the Chilean state did not guarantee to Mr. Pablo Vilches his right to health by failing to give him information about his health status. This case serves as a parameter to the present discussion because it addresses the important topic of the obligation for providing information and awareness for people in vulnerability, especially concerning their right to health, established in the Article 26 of the American Convention on Human Rights. Moreover, we cannot forget that there are several human rights violations that are associated with the outcomes of mobility restrictions, such as quarantines and lockdowns, such as shortage of food and medical supplies and medical equipment, mental health diseases, stigma, xenophobia, losing access to school and proper education, and inequalities around the access to national health systems. There is no acceptable ground for states to apply such measures indiscriminately. The arbitrary interference of states in the freedoms of people, cumulated with misinformation, violates human rights, and the democratic clause of constitutionalized states. Thank you.
Thank you. Now we would like to give the floor to Tilburg University. You have 2 minutes for your second rebuttals.
Am I audible?
Yes.
Yep. First, I would like to start by elaborating on the argument that my colleague, Mr. Fransavi, brought up in the opening statement. Freedom of movement is not an absolute right, and many of the treaties that found the basis of international law recognize this. In fact, the ICCPR, which my colleague mentioned, as well as the ECHR. But also, the ICESCR recognizes in Article 12 the prevention, treatment, and control of epidemic, endemic, occupational, and other diseases is a legitimate goal that shall be pursued by governments in policymaking to protect the masses, meaning that not only we can, out of necessity, withhold the right to freedom of movement, but also it is our duty to prioritize measures to deal with the pandemic. The proposition mentions that in certain cases, the legal requirements laid out were not met as these policies were designed and enacted. However, we have to acknowledge the fact that we were dealing with a global crisis, the pandemic, and in those urgent times, it was perhaps out of the need to act quicker in order to save all the lives that are at stake. And the very fact that we did not know what we are dealing with here, there was a lot of uncertainty regarding well, perhaps how serious this could be. So they had to take the measures that they deemed necessary at the time. And that is what they did. But also, one other thing that I would like to mention is that the legal challenges that were brought against many of the lockdowns in different countries were the exception rather than the rule. We see that, for example, in Australia, the Supreme Court confirmed the constitutionality of the lockdowns. And in many other countries, there were no legal challenges brought forth against the lockdowns and measures whatsoever. Thank you.
Thank you. So now it's time for the closing statements. I would like to give the floor to Domhelder Law School. You have 2 minutes.
First of all, am I visible and audible?
Yes.
Finally, honorable judges, we are not discussing the limitation of relative rights. We are discussing the distinctive implications of indiscriminate lockdown. Firstly, the duties of states imply measures to be undertaken in a public health crisis. However, in accordance with the COVID-19 and human rights reports from the United Nations, the livelihood and security of the peoples are substantially affected by the lockdown. Those dreadful consequences have to be eradicated, respecting the goals adopted in the Agenda 2030, more specifically, the Sustainable Development Goal number 1, which is to end poverty. Thus, although emergency regulations are under the state's competence, it shall not compromise human rights and other internationally prescribed obligations. Besides, it is fundamental to respect the principles of legality, necessity, proportionality, and equity. That's the reason behind Article 17 of the International Health Regulations, which determines not only the temporary character of those measures, as the obligation to comply with all international standards and instruments. States are responsible for the social and juridical status of their peoples, implying the necessity of social assistance plans, especially for the most vulnerable, disrupting the idea of an indiscriminate approach. Finally, pursuant to the proportionality, there are other measures prior to the lockdown, exemplified in Article 18 of the International Health Regulations. The exercise of human rights shall be carefully assessed, especially by the most vulnerable, in order for equitable measures to prevail even in health crisis. Thank you.
Thank you. And now to finish, I would like to give the floor to Tilburg University. You have 2 minutes to deliver your closing statements.
Thank you very much, Your Honor. The opposition wants to react to the statements made by my counter colleague on the other side. They have mentioned and stressed the point that the societal and economic considerations should be met and taken into account when trying to impose an indiscriminate lockdown. And they are trying to argue that such currently is not being taken into account. However, we are of the opinion that considerations are taken into account. We can see, for instance, that most countries in the world do not appeal to emergency powers to try to impose a lockdown, which already states that there is no arbitrary nature of such a lockdown. No, there is a lockdown being imposed because of health considerations. This is, for instance, seen in England, where they have imposed a lockdown based not only on constitutional powers, but based on national administrative legislation, such as the Control of Disease Act. Can also be seen in Nepal, where we see that the Infectious Disease Act is the legal basis of such lockdown, or India, who appeals to the Epidemic Diseases Act. And this implies that such countries are imposing such lockdown and trying to mitigate only such lockdown when there is a health concern. And when that health concern is not present anymore, they will loosen up the lockdown. And we can see that in England, in India, and in Nepal. Ladies and gentlemen, I want to conclude our statements for today. Our submissions today try to stress the point that the lockdown does not constitute a violation of human rights, as long as such lockdown is proportional and balanced, elaborated further upon by my colleague Rob Neer. But also such lockdown is in place to safeguard the right to public health, as well as the fact that such lockdown is taking into consideration the social and economic effects of such, and is therefore intrusive enough. Thank you very much.
Thank you. So now we're done with the debate. As usual, before we leave, I would like to give you the opportunity to reflect on your on this debate and give us some feedbacks. So we can start with Mr. Ndizeng.
Yeah, thank you very much. It was a very interesting debate indeed. I did not expect certain arguments raised by my by my distinguished counter colleague on the other side. It was a very creative point of attack, and it's very exciting to see.
Thank you. Mr. Lucas Souza.
I'm very much thankful for this debate. It was such an outstanding point of view. I hope everyone has the opportunity to publish all their arguments that were very well researched, and I thank you all for the outstanding debate. Thank you.
Thank you. Mr. Radmer Khosrokava.
Well, I just want to say it was a pleasure participating in this debate. It was very insightful, and I would like to thank everyone who contributed to the organization and the debate itself.
Thank you. Ms. Laura Rosas.
I'd like to thank the organization, my fellow colleagues, and my counterparts for this amazing debate.
Thank you. Mr. Rami Fransawi.
Yeah, I just want to say it was a really interesting debate. I think very challenging for both sides, and just want to thank everyone here for making it happen.
Thank you. And Mr. Fabrizio Lafuente.
Looking forward to debate this specific topic, which is very important to me, but I would like to thank all my counterparts for this very prosperous debate. Thank you.
Thank you. We also have the coaches for each team, so maybe you want to say a word. First, Miss Lorena Bastianetto.
Thank you, Elise. Just like to welcome and thank you everyone for this outstanding debate. And hopefully we can debate once more in the future. Thank you very much.
Thank you. And finally, Mr. Lennart Telemans.
Yeah, I agree with what everything has been said. Very interesting debate, strong arguments on both, from both positions. And I think that, you know, as in most debates, truth probably lies in the middle. And I also want to thank everyone for this wonderful debate.
Great, thank you. Now I can give the floor to Mr. Laurent, and he will conclude the meeting, I guess.
Yes, thank you very much. So, Mr. Lange and Ms. Urbanova as well, because we have as well some information to give you. So, yes, great debate, very, very good quality. That's what I could tell, because it was indeed heavily researched on both sides. Yes, on all these aspects, which are very, I would say, from this year. I mean, from this period of end of pandemic, let's say. So yes, a lot of questions that you managed to debate. So yes, so today is a match for the 8th finals, and then of course the team who wins the match will move to the quarterfinals, which will be in the end of May, let's say around the 27th, 28th of May. So then you can see already in your agenda. Of course, at that time it will be let's say quite I would say even more difficult, because the 8 best teams will be at that stage. So the judge for this match, of course, are aware that the match takes place today, and we will need to get their feedback in a way that we can announce before the weekend the results. So you will receive, as usual, the forms with the feedback and advice for the next steps or next match you would have. And yes, this weekend as well. Before the weekend, we have an event, a networking event that my colleague would like to say some words already.
Yes, first of all, thank you everyone for your preparation and for the execution of your arguments. It's been a pleasure to see your progress throughout the competition, and I hope this has been an exciting experience for all of you. And whatever the results of this match, we hope to see you in the events that will be happening for the rest of the competition, starting with the networking event this week on the 12th of May, starting at 6 p.m. Dutch time. It's happening on the Gather online platform. And as well, hopefully next year, since there is a one-time participation rule, you can join the competition either as a student organizer or a coach for your team, or if you are graduating and you will be working with law, you might even also qualify as a judge for the group phase. So either way, very excited to see all of you again, and as soon as possible this week. The results, as my colleague said, at the earliest, you'll receive the results on the day of the networking event. If we have results of the matches that took place up until this point, we'll also do the announcement of the winners during the event, and of course the forms will be sent privately to both teams with the feedback of the judges. And as to the agenda, today it's still possible to register for the event. The Gather platform has a limited amount of available spots, so we'll need to be doing reservations for every registration. So once your reservation has been confirmed by our team, we'll reserve the spot on the server, and then you will receive the access information as well as the instruction manual how to join in. If you participated in the workshops in February, you will be already familiar with the platform. If not, that's completely fine. You'll have the tutorial space, and of course our team will be present to guide you through the platform as well.
Yes, and as it was mentioned by one of the participants today, you can as well publish your research that you have done during these last 10 days, because that was, as you said, quite well argumented, and as well you had to prepare both sides. So of course you can publish everything you have found in favor and against in the form of an article that you could submit maybe to the foundation, then you get published on your own name. So on the THIULDT International, which is the publishing platform we have. Finally, yes, today or tomorrow I will be sending as well an email about an event organized next week, which doesn't have any registration form, but simply it is open actually to all the students of the tournament. So that will be about career opportunities, etc. For law students. Dr. Bastianetto knows very well what it is about, because she will be as well speaking at that event. But what I want to tell is that you will receive this email because you are all invited, and then yes, that will be coming after the event we have, the networking event we have this week. So voilà. So thanks again to everybody. Thank you as well, Miss Varley, as well, for hosting the match. Thank you, Miss Urbanova. And as well, yes, we hope to see you this weekend. Yes, don't forget that all participants receive a certificate of participation that you can use. I mean, you can use for your studies, or as well as the coach. So it is very important as well as the coach knows that they will receive as well a certificate of participation for this edition. So voilà. So it's the last thing I wanted to tell for today. Thank you again, and we'll see you very, very soon. Thanks again. Bye-bye in Brazil, bye-bye in the Netherlands. I'm in the Netherlands, but still.
Thank you.
Thank you. Bye-bye.
Bye.